Hi, I'm Elizabeth Lon. I'm an immigration lawyer at LM Law Group. And today I have George Hamsel from Learners here. George is an employment lawyer with Learners. When we're talking about businesses bringing employees to Canada, oftentimes there's an assumption that, well, we'll just use the same employment contract that we did in the US with the same employees. They're doing almost the same job, it's just a different location. George, are there any issues with them doing this?
There might be a few with that sort of proposal. So the first thing you should know if you're a US company hiring workers to work in Ontario is that the concept in the US called at-will employment, it just doesn't exist here. It's sort of a foreign concept. We don't really have a similar type of concept here in Ontario. So for Ontario employees, they're presumptively entitled to what's called reasonable notice upon termination. And it's determined by a number of factors, probably the most important of which is your tenure and the sort of level of responsibility you have within the company. And so this sort of liability can be quite onerous, and if you're not used to it, it can be quite shocking to you. So something to sort of think about is to be aware of that if you're coming into this jurisdiction, and there are a lot of great reasons to do so. But if you're going to do that, it's something that you should be sort of budgeting for ahead of time as part of your workforce costs. So just to give you an example, reasonable notice can get as high as 24 months pay, right? And there are now some decisions in Ontario that go even higher than that. So it is just something to be aware of. It can be a bit of a culture shock. So I've had clients myself who've come into this jurisdiction and just not been aware of that.
Yeah, and I think it's a lot of it is planning and having that contract that protects your rights before you get started. Even applying for immigration. So, when we're applying for a work permit, we are putting in that employment contract, and you're subject to the terms of that employment contract afterwards when they do immigration audits. So making sure that you have the proper agreements in place so you protect yourself so that you don't have to pay the 24 months of severance pay, etc. That's going to be very important.
Yeah, absolutely. Something that you can do here in this jurisdiction is that you can contract out of those common law reasonable notice entitlements with a properly drafted termination provision. Now, I do want to say at the outset, it can be difficult to draft one that is actually enforceable. The courts are very particular about what they want to see and what's allowed with those sorts of provisions. So best thing you can do is to get legal advice, get somebody who works in the area to be able to draft a termination provision. So just by way of example, a 20-year employee, they might be entitled to 20 months or more of notice upon termination under what's called reasonable notice, or the common law as it's commonly referred to here. If you have a properly drafted employment agreement with a termination provision, it can be as low as 8 weeks of pay. So it is something that you should really look into. Make sure, put the time and money into it up front, just to make sure that you have something that can withstand judicial scrutiny if it comes to that.
Wow, that's certainly a huge difference. Now, George, there's another thing I wanted to ask you. A lot of companies hire these employers of record in Canada so that it seems like the employee is an employee of a Canadian company, and that Canadian company has nothing to do. They don't have any relationship with the actual company in the States, for example. And it seems sometimes that it's easier to just do that instead of creating their own company in Canada and having them as the employer in Canada. They hire the Canadian company.
Right.
But on the immigration side, that creates a host of issues. For example, you're not going to be able to transfer that employee back to the US afterwards through the L1 because there's no corporate relationship between the Canadian company and the US company. And also there could be issues with the employee later on getting permanent residence, etc., depending on the circumstances of the case. Do you see any issues from the employment law side with these kind of arrangements?
In Canada and in Ontario, we have this concept called common employer, or the common employer doctrine, which basically says this, that if you're a separate company from the employer of record, let's say, that is not a sort of fail-safe way to escape liability. So all the stuff I said about reasonable notice and entitlements upon termination, right? You can still get that to sort of stick to the original US company through the imposition of this doctrine. And basically what the court would do is just undertake a factual analysis and say, you know, who's really calling the shots here? And if it's this US company that's sort of directing the way these employees work, if they're cutting the check for the employees, then it's going to be a pretty clear case that, well, actually the employer is really this other company that's situated in the US. And so the court will probably, in that case, impose those types of liabilities for termination pay, severance pay on that US company.
And that can be quite problematic because the US company at that point doesn't actually have a Canadian employment agreement with the employee. So you're not able to protect yourself against or contract yourself out of those kind of common law requirements of the 24 months, etc., of pay. Whereas if you actually employed that employee and you had that proper employer-employee relationship in Canada, then you would be able to control that. The moral of the story is, before you start bringing your employees to Canada, get some proper advice, get some proper planning advice so that in the future, you're protected.